hearing last Saturday based on a removal last Friday. At the request of council, we've adjourned to today to give them a chance to chat. And we're going to go through all of our preliminary proceedings today. May I have the names of our participants, please?
Good afternoon, Alex.
Oh, let's start with our attorney deadline.
Good afternoon, Your Honor. Ariel Berger here as the LGIL for the minor children.
Ms. Stasia Thomas, counsel for the department.
Nikki Jones, foster or CPS worker, side of the case.
Leanne Higgins, mother of the children.
Okay. All right, Mr. Liza.
Liza Hope.
Sorry, Liza Hope. Thank you.
Liza Hope. Good afternoon, Your Honor. Alex Liza Hope appearing on behalf of the respondent father.
Okay.
The record should reflect that my client, Matthew Higgins, is also attending this Zoom proceeding. Secondly, Your Honor, I need to point out that I don't have a complete copy of the petition. I think that's one of the points that Your Honor needs to bring up and it's under MCR 3.965 B4. The problem is I have an addendum, I have an order, but I don't have the petition, nor if there are attachments other than the addendum, I do not have them as well.
So who did you receive what you do have from?
From my client, and I asked him about it on Friday. Yesterday I met with him, and he advised me he gave me what he had, and that includes the addendum, and attached to the addendum is the order, and there is nothing else, Your Honor. I do not have the petition. I don't have the case number on the petition. The order actually makes reference to a spot where the case number needs to be, but it's not in there. I did call the clerk today at 11:50 a.m. Did not take the call, but I had to leave a voicemail message. I not only called because of that, Your Honor, I called because I wanted to be able to file my appearance, wanted to be able to file my jury demand. I don't know if your court does electronic filing or not, and I wanted to inquire as to that. So that's where we stand. I don't have it.
Thank you. Ms. Thomas?
Your Honor, it would be my expectation that Ms. Jones would have provided Mr. Higgins with the complete filing. And Mr. Lizahob, it would be a JCO 4B with the addendum. And then the judges signed JCO 5B.
Don't have it. I have the form number that I have is JC05B. And there is a page, I don't think it's part of the JC05B. It lists, it says, no, that's part of the order. I apologize, but it's blank. There's no references to the identifying information on that particular page. So maybe the order needs to be amended, but more, and I will comment this, everyone, I've got a copy of like a, I don't know if it's an text or email, but it says, "Good afternoon. The court has reviewed your emergency motion. The motion is..."
Mr. Lizahob, I'm sorry, Your Honor. May we just do this in a sidebar? I don't believe that this is necessary for the record. If there was an issue with documents that were not received, I remained available to counsel to rectify that. So if we could just address this off the record, and I can also provide a copy to Mr. Lizahob electronically.
Well, Your Honor, I think it's part of the court role, and I think it's important that it is documented that I don't have it. And I know I appreciate they want to provide it to me, but I don't want to make it a sidebar.
Well, there's a JC 12B that has been filed from Ms. Jones indicating that she served the JCO5B, the petition and attachments, and your client signed personal service that he had received it. So that is part of the court record already.
No, I don't have it. And if he signed it, maybe he didn't examine it before he signed it. But I'm telling you, he would have given it to me. This is a serious matter. I do not have it.
Well, you did not have an appearance in at the time we filed for an emergency purpose. So based on our records, we have it.
Your Honor, could I please get a copy of the pleadings?
I don't think anyone's telling you you can't have a copy. So, but I would encourage you to feel free to reach out to Ms. Thomas in the future if you feel that something is missing. I know we did address this Saturday, and I would have hoped that you could have reached out to her and secured another copy, or the clerk's office if you needed that, especially given the fact that your client was served. But I'm happy to allow Ms. Thomas to take some testimony from Ms. Jones on that. Are you interested in that, Ms. Thomas?
If that will satisfy the court, Your Honor.
All right, Ms. Thomas.
Ms. Jones, what is your role in this matter?
I am the CPS investigator assigned to the case.
As the investigator, were you responsible for filing the petition and serving it to the parents?
Yes,
And to the best of your knowledge, what were the documents that you provided to Mr. Higgins?
I provided Mr. Higgins the JC05B along with a copy of the petition, which he acknowledged receipt, and we talked about those allegations, some of those yesterday. And then also there was one attachment in which his attorney was referencing that looked like an email.
And when you refer to the petition, are you referring to the JCO4B with the addendum or just the addendum?
Just the addendum.
Is there a reason you did not provide him with the JCO4B?
I'm looking at my packet. There is not, I wasn't clear about that. So I did not give him the JCO4B. And that's not listed on the proof of service.
Okay, but the addendum is not titled petition. It's titled addendum, correct?
Correct.
Okay, so your proof of service needs to be modified. Is that accurate?
I'm going to object to the leading nature of the question.
Well, response, Ms. Thomas?
I mean, at this point in time, I can restate it, but I also this is a not trial, and so our rules of evidence do not apply here, which would include questioning of my witness to ensure that Mr. Lizahobe has what he needs.
Well, Your Honor, I object because it's leading number one and number two. It's actually a motion that should be with the court, not with the witness.
Well, leading questions are permissible for purposes of efficiency, and in this particular case, I find it to be efficient and not necessarily suggestive of anything or problematic of anything. So I'm going to allow the question. Ms. Jones, you may answer if you recall.
So what I served him was a JC05B and also all the addendum with pages 1 through 6, which lists the allegations.
And so you did not provide him though with the actual petition, which is the JCO4B.
Correct.
Okay, is there a reason why?
There is not. I missed it. It's not listed on my proof of service.
Thank you. Your Honor, I have no further questions of Ms. Jones.
Do you have any questions, Mr. Lizahobe?
No, Your Honor.
Okay, Ms. Berger?
No, Judge, thank you.
All right, well, we will need to have the file corrected. The proof of service does indicate JCO5B petition and attachments of 1. So, Ms. Jones, if that's an error, we're going to need you to remedy that. Mr. Lizahobe, do you have an email address that you would like to provide so that a copy of this perhaps could be expedited over to you, or how would you prefer that this be remedied?
I'd request that, Judge. That's sufficient, absolutely.
Ms. Berger, do you have a copy of all of the documents, the petition, the attachments, the order?
I do.
It sounds like you may need some additional time then, or how do you want to address this?
I would appreciate it, Judge. That would give me the opportunity to study the petition for whatever it states, number one. Number two, I also need the additional time to file my appearance and a jury demand. It has to be timely, obviously. And so for those reasons, I'm going to request a short adjournment. We're still within the 14 days allowed by the court rule. I do believe good cause exists for that. I have my calendar ready, and I'm ready, willing, able to resume this hearing as allowed by the judge, by the court.
Any objections to that, Ms. Thomas, Ms. Berger?
No, Your Honor.
No, Your Honor, I was able to conduct a home visit with the minor children and with mother. And mom did supply me a copy of an ex parte order suspending father's parenting time through Wayne County in front of the court. So I don't believe that it would cause any harm at this point. There's a no contact with this court. There's suspended parenting time through the court in Wayne County. So I don't see a harm in adjourning for a short period again.
Your Honor, can I comment something, please?
Sure.
We never got a copy of any ex parte order from the Wayne County Circuit Court, just for the record. And if Ms. Berger could please provide my office with a copy of that as well, I would really appreciate it.
Well, I'm not sure that's Ms. Berger's obligation. I will leave it to you to handle that separately. I will tell you I have some time Monday afternoon.
I'm sorry, what day are you on?
Monday afternoon, the 21st.
Wide open, Judge.
Well, I think 1 o'clock is going to work better for my schedule. So if you wouldn't mind, Ms. Thomas, we'll go ahead and schedule for 1 o'clock on Monday, the 21st. And then, of course, we'll look for that full set of documents to be provided, and the appearance to be, jury demand to be filed.
Yes, Your Honor.
For all those reasons, the court will grant the adjournment, all prior orders remaining in full force and effect pending the resumption of our proceedings on Monday, 1 o'clock.
Monday, the 21st.
regarding ad litem.
Good morning, Your Honor. William Amadeo, P76194 for the department, appearing via Zoom. My workers, please state your name for Judge Sala.
I'd make that from the department.
Brittany Kelly from the department.
Michael McFarland, representing Mother.
Keely Yankee, Mother.
Very good. We also have, I think, Dan Bartelt with us.
Yes.
Yes, welcome. Good morning. Thank you also for your patience. All right, Mr. Amadeo, comments about our sidebar?
Thank you, Your Honor. We did have two sidebars this morning. It's the department's position right now that we would be open to a reunification goal if Miss Yankee wanted to plead no contest to something. It's my understanding that she will not plead to anything. At this point, I ask, based upon all that, we set this for a jury trial and do a review today. I'll turn to my brother and sister counsel, see if that's an accurate recitation of everything.
It is.
It is.
All right, thank you for that. We've set a pretrial, a final pretrial, not necessarily a pretrial review because it's not our full 9 days, plus these children are with their parents, so we really don't need a review other than every 6 months. So we've set a final pretrial for Monday, October 23rd at 1:30. And we've set jury trial dates for October 30th and October 31st, commencing at 9 o'clock each day. For purposes of today's pretrial review, Ms. Heiss.
Thank you, Your Honor. I visited with this child face to face, and she, a lot of factors combined to make her a very resilient child. She's healthy, she's developmentally advanced, she's so positive about school. It shows a lot about her environment. She wants to see mom more. We see the visit notes indicating how the visits go. I think that's positive for her. Overall, if dad would get a custody order, I think we could be assured that he can protect this child, but that's not something that's gonna happen. Apparently, we can't get to that step. So because of that, to continue the case towards jury trial is something that makes sense for the child and to continue the visits. Thank you.
Mr. Amadeo?
Thank you, Your Honor. Department calls Megan McVeigh to the stand. And Megan, what is your job title?
I'm an ongoing Children's Protective Services worker at the Department of Health and Human Services.
And how long have you been doing that?
Almost 16 years.
Okay. And how long have you been on this particular case?
This particular case would have been about 90 days, about 30 days after the initial petition date.
And who's Brittany Kelly?
She is the investigating worker on the case.
And has Brittany Kelly worked on this matter as well?
Yes,
Would it be fair to say that you and Miss Kelly know more about this case than anybody else?
yes.
What's the current permanency goal for the child?
The current goal is we've been doing reunification services with the mother.
Okay, and is there a concurrent goal or not?
No, because they're placed with a parent. She's placed with a parent.
Okay, is Miss Yonke the respondent mother?
Yes,
Has she rectified the barriers that cause the child to come into care?
not yet.
Can you explain to Judge Sala what services you offered?
Yes, she's been offered supervised parenting time with Pauline Edwards. We were able to make an intensive home-based therapy referral, which she has actively been participating in, that just started. And the the child has been seeing Renee Moore for counseling. And there's an additional service that we would like to get done. It's called a psychosexual assessment that's been recommended by the child's counselor to see if there's any risk of harm. Ms. Yonke is more than willing to do whatever she needs to do. It's just been a process of locating somebody that can do that assessment and getting it set up. That's been difficult.
Would it be fair to say that you don't want to dismiss this case at this point because you're still concerned about the child's safety?
Yes,
And would it also be fair to say that you still want to continue the investigative services you mentioned to the court?
yes.
Has there been a change in Stella's placement during the review period?
No, she's been placed with her father.
Okay, what's the current parenting time plan?
Right now, it started with one visit a week for 2 hours each week, and it's been increased to two-hour visits between the child and the mother, supervised by Pauline Edwards.
Has the placement exercised reasonable and prudent care during this time period?
Yes,
Being involved in this case, would a remedy that seems fair to you be reunification at some point?
at some point, it would be depending on the assessments and the recommendations from service providers.
So to be clear, you still would have some review to do. Is that accurate?
Yes,
Are there any additional needs the child that are not being met at this time?
not at this time.
Is there anything you want to add for Judge Sala to consider today?
Not at this time.
At this point, Your Honor, I have no further questions. I ask that the court report and supporting documents be admitted for the record.
Maybe I'm a bit confused. Is it your position you would not accept my client entering a no contest plea for the goal of reunification today?
That I didn't know anything about her accepting a plea.
No, my question is, or is it your position that you would not accept no contest plea from her today with the goal of reunification?
I believe that would be a question for my attorney.
Okay, fair enough. This assessment that you've mentioned, how long have you been attempting to get that?
Since the last court hearing, it's difficulty finding a qualified professional. I believe I have found one, and it's been difficult scheduling. It's with Dr. Randy Haugen.
Where is he located?
He is located out of Battle Creek, but he does come to the Hillsdale County MDHHS, which would be a lot closer for Miss Yonke than Battle Creek.
You know anything about his schedule or the timeline for this?
Not yet.
So it might not even be completed prior, possibly.
In hopes it would be.
Okay, fair enough. Would this minor child Are you aware that the child's had head lice 5 times and now has an active case of pintail worms?
Yes,
What are we doing to address that medical issue?
she went to the doctor to address the worms, and with the head lice, she hasn't, at this time, she does not have head lice right now, but she has had it a couple of times.
What seems to be the cause there, you know?
I think they're really difficult to get rid of.
Yeah, apparently mom has been advised on that, correct?
Yes,
Has mom been invited to attend the doctor's appointment on that?
I'm not sure. I would have to ask Mr. Martell.
You think that she does not have a right to be there?
She could be there, yes.
Has she been notified about that?
Yes, she was notified, but not by me personally, but Ms. Yunke and Mr. Martell are in regular communication with each other, and he keeps her well up to date on the well-being of the child.
And lastly, it sounds as though you indicate my client is willing and cooperative to participate in the assessment that you mentioned, correct?
Yes.
Nothing further.
Ms. Hyde?
What is being done to investigate the source of these lice contaminations?
So I didn't realize that it had been that many times, but as far as I know, that it's been taken care of at this point. She didn't miss any school last year because of the lice concerns.
So it wasn't 4 over the summer, 4 outbreaks, it's 4 maybe total since January when we opened the case.
I don't know how many it's been, to be honest with you.
And then the worm situation, what's being done to investigate the source of that?
I mean, I wouldn't investigate the source of that. I would ask that the father take the child to the doctor to have the doctor address that, which he's reported that he did.
And what was the outcome?
I'm not sure.
Okay, and then,
That just happened a few days ago.
so this child has been seen by Brene Moore since about June, is that right?
Yes.
What was the delay in getting her into counseling support?
There was belief that she didn't need the counseling support. And then we had a court hearing where counseling support was recommended by the court, and we immediately started it after that.
So
She's been doing well in counseling. Ms. Moore feels that she doesn't necessarily need like every weekly counseling. She's a well-adjusted child.
So if there's no risk of harm from her mother for mental health, is that what you're saying? Mother has not affected this child's mental health.
I think the concern is affecting the mental health of the siblings as well.
Are those kids in counseling?
Yes.
And can we see those records to know what they're working on?
I didn't include them because they're not a part of this case. They're not listed as a part of this case. But in Ms. Moore's letter that I attached, it talks about the concern between the child and her brother's relationship.
But certainly we're not removing this child from her mother because the boys might be jealous that she brings home a new toy.
No, that's not.
So we're removing this child from her mother because of the mother's risk of harm to the boy, at least to the victim.
Right, and the law also states what would be, we have to consider what is done to one child will be done to another child.
But we don't know what was done to the other child if you don't give us those records. So I don't know if he's
I believe the records have been provided, like the CMC interview and all those, they have been provided, but I haven't provided the individual counseling records because they're not a part of the court case.
Do we have them?
I could get them.
Okay, I think they are part of the case because I can't tell if he's in counseling for a toothache or if he's in counseling because he's been sexually assaulted, and it makes a difference to protecting this child. So even if I can get a summary, you know, if that child is just distraught and on all kinds of medicine and not doing well because of the abuse and he's triggered and having all kinds of just trouble in school, that's different than this child who doesn't seem to even need counseling. So if you would provide me with some kind of an update on that child's progress, I don't need to know the details, so that I understand the harm to this child through understanding the harm to that child.
Right, and I can do that. That's not a problem.
Do you think this child is at risk for sexual assault from her mother?
I would have to defer to the psychosexual evaluation that was recommended, and I would go off of those recommendations.
But with no criminal charges pending, if she goes to the psychosexual evaluation, if she denies doing anything, that's not gonna be good in the psychosexual evaluation. Because she's in denial and not willing to protect her kid. And if she admits it, that's a crime, right?
Right.
So what do we do about that? How do you anticipate that she can win in a psychosexual evaluation?
I don't think there's winning. I think it would just be to evaluate the risk. And they would be provided all of the evidence from the court that the court's been provided.
And if she denies that she did it?
I'm not sure. I've actually, in the 16 years I've done this job, never done a psychosexual evaluation. So this will be my first one.
Well, I don't know that it's realistic to expect her to do that when she has criminal liability if she goes one way, and if she denies, then she's got a problem here. I don't know how telling the truth. Anyway, all right, so, but you did find a provider, and is she amenable to, have you asked her if she'll do the test? Psychosexual evaluation?
Dr. Halkin, I haven't been able to get a hold of him. We've been playing phone tag back and forth.
Do you think this dad is ready to supervise some visits, or do you think we still need the level of L&L parent aid for supervision?
I haven't discussed that with Mr. Bartel. I believe he did, at one point, they said that it would be okay. I think the concern would be like making sure it's not in the home where the other children are.
Absolutely, and Mr. Bartel could be prepared with when to shut a visit down, what not to talk about in a visit, and to provide us notes, whether mom's on time, if she stays the whole time, that kind of thing. Because he does supervise the video contact every day, right?
Yes.
The other thing that I'm looking for is whether we can trust Mr. Bartel to supervise in the absence of the pressure from the state. So you would consider getting him ready to supervise visits?
We could explore that, certainly, and I would also want to go off the recommendations of Renee Moore, but because so far we've been, and the last court order did say that the visits should be supervised and that there should be a recommendation from a counselor regarding the supervised visits. So that's where I have been going off the recommendation of the child's counselor.
And she's not really clear about, her recommendation doesn't say one way or the other about who should supervise, whether it should be professional level, therapeutic level, or.
I can get that recommendation from her.
Okay, that'd be fine. So I have nothing further. Thank you.
Any redirect, Mr. Amadeo?
Briefly, thank you, Your Honor. Megan, there was a lot of talk about the criminal investigation. Let's be clear. Is your concern a criminal investigation, or is your concern protecting the children?
Protecting the children.
And do you think it's possible, since this has been brought up on cross-examination, that just because Junkie was not charged criminally, there still may have been sexual activity that broke the law?
Yes.
And is your concern to make sure, based on the information you had, that these children are completely safe?
Could you repeat that, please?
Based on the information you have, is safety of the children your only concern right now?
Yes. Yes, it is.
And do you feel the further investigation you need to do will help assure fairness across the board on this case?
Yes, I do.
Nothing further. Thank you.
Just a couple questions, if I might, following up on the hearing items. You're aware that this court usually affords parents 3 visits, 2 hours a week, correct?
Correct.
My client's getting 2 visits, 2 hours a week, correct?
Right, and the recommendations of Ms. Moore, and according to the letter, at this time was 1 visit per week. So I've been going off the recommendations of Ms. Moore.
Well, we're actually exceeding that recommendation, right?
Yes.
So, and there's been no harm to the child, correct?
No.
So why not expand to the traditional 3 times in 2 hours if there's no exhibited harm at 2 hours, 2-hour visits per week?
I would say I've been deferring, going off of the recommendations of the counselor. And that's what her current recommendations are. She did make a recent recommendation after this letter that we could increase the visits because the visits have been going well.
Okay.
I don't necessarily have an issue with 3 visits per week.
So when do you anticipate that we could commence that?
as soon as we're able to set it up.
Okay,
And possibly, I mean, we could talk about Mr. Bartelt supervising a visit.
okay.
That might make things easier for everybody.
And I am not familiar, as the guardian ad litem is not familiar with this sexual evaluation, assessment evaluation. Would it be possible for you to provide the contact information to me for this doctor so I can talk to him? Because I likewise am not sure, you know, my client might want me present, might just take the fifth on all of this. So it may be just a waste of everybody's time. So I'd kind of like to find out ahead of time before we commit the doctor and my client to this, if you don't mind.
Yes, I can do that.
Would you also advise the doctor that I would be contacting the doctor after I receive a contact?
Sure. Yes, I can do that.
Thank you. And I don't mind if you're on the phone with me if you would like to be.
Okay, we can do that.
Thank you. Nothing further.
Any requests, Ms. Heiss? No. Thank you for your testimony and your attendance. Any other witnesses, Mr. Amadeo?
No, Your Honor.
Nothing further?
Ms. Heiss?
Nothing further, thank you.
Any comments?
Yes, Your Honor, I'll be brief. I don't know if the court can order the assessment, but if so, I know it's something my workers would like to do. We'll ask this go to review. We'll ask that this go to a jury trial. And to be clear, because I did appreciate the, no offense, Mr. McFarland, the mischaracterization. I've been very clear that if Ms. Yunke wanted to enter a no contest plea, we would have taken that. We would have went to reunification. It's my understanding that's not what she wants. She wants to go to trial. And respectfully, Judge, if this was a male respondent parent, we wouldn't be having the same conversation. My department's been over backwards to be fair in this situation. If she wants to go to trial, we'll accommodate. Thank you.
Any comments?
Court no services.
No comments, thank you.
Well, the court finds all interested parties were given notice for purposes of today's pretrial review. It's come to the attention of the court that at our last time we addressed this matter, the pretrial was adjourned, and it should also be noted that the jury trial was also adjourned to allow the parties to review some of the pieces of evidence that are relevant in this case, including a CAC video interview and some other pieces of information that needed an additional protective order to allow that to happen. So those things have occurred. The court has set a pretrial and a jury trial date. So those items are addressed and have a pathway moving forward. If the parties wish to address a resolution, then we'll have an opportunity to do that at the pretrial juncture. In the meantime, the parties have been operating under an agreement effectively that has kept this child really from being removed or under the formal jurisdiction of the court. And that included the agreement between the mother and the father to have virtual visits, to have visitation, but all supervised. And at the last juncture, of course, the directive to have father get the child enrolled with a counselor to have a professional weigh in about visitation and whether or not there remains a risk of harm associated with allowing this parent unsupervised time with the child. It's come to the court's attention that there will not be criminal charges being pursued, at least at this juncture. That's the understanding of all of the parties against the mother. LNL parent aid visit observations do not present any real concerns. I'm looking at the letter from Ms. Moore. It does not really seem to indicate that there's a risk of harm associated with parenting. She expressed some observations about the child, but not really any indication that there's a risk. She does indicate, as Ms. McVeigh shared with us today, that it could be beneficial for Ms. Yunke to have a psychosexual assessment to discern the risk of harm established during visitation. And really, given the allegations, it's about whether or not those particular choices or the lack of boundaries, and assuming the allegations are all correct, it would be whether or not that decision-making process presents a risk of harm to this child, right? So I can see the benefit to having the psychosexual assessment. I'll note in the order that we'd like the department to explore that to see if we can find someone to do that for us. But in the meantime, I would like the visitation expanded. But again, this is all based on the agreement of the parents. I think we have an assumption here that the department has the discretion to oversee parenting time, but we really don't. So it'll be up to Mr. Dan Bartelt and mother to determine that. But appreciate you continuing to observe the supervised aspect of that until we can get the psychosexual assault assessment, in place. And please make sure that you communicate with Ms. McVeigh about any parenting time that you arrange. I can't see a risk of harm at this juncture associated with increasing the time that you're spending with your child. So those are my comments on that point. So I'm not ordering anything because I don't have the authority. I'm asking you to continue to respect what the two of you have agreed to so far, which is don't spend any alone time with your daughter just yet until we get one more assessment done. And hopefully we'll have an answer to which direction this case is going in late October. So I appreciate the parents continuing to respect the court and respect each other and the child and put her first, abiding by their safety plan. And I do think Ms. McVeigh is certainly making efforts to monitor the situation and provide services. So thank you. And thank you also to Ms. Heiss for her vigilance on behalf of the child. So we're all in satisfaction of our obligations here. Let's get some answers on which way this case is going in October. And unless there's any questions, that's all for today. And we'll see you on the 23rd.
Thank you, Eric.
Thank you. Have a good day.
Sarah Thomas, counsel for the department.
Jamie Dillon, Lenawee DHHS foster care worker.
Michael McFarland representing mother. Is she joining us?
Okay, do we have Ms. Jessica Gleason with us by Zoom?
Yes, mother of
Okay, you're breaking up pretty badly, so I'm going to terminate your video feed. Can you try to give us your name again and see if that works any better?
Jessica Gleason, mother.
Yeah, that's not going to work. So I guess you'll have to just do your best to listen in on today's hearing.
Can I ask her to perhaps move a little bit closer to the microphone?
It's not going to help.
It's not.
She's breaking up.
Okay.
She's frozen.
Good morning, Your Honor. Ariel Berger here on behalf of Father Donald Bundy.
Please.
Thank you. I can't even get her muted. The connection. Oh, and we lost her. Well, she's welcome to join us. It does look like she has an Adrian address, so unfortunately she wasn't able to be here in person. But we all know the rule is like an old shoe at this point. If you want to participate by Zoom, you have to have a good connection. All right, let's head into it then. Further appearances. Did we get everybody? Your name.
Donald Bundy of Remington, or Father of Remington, sorry.
And Ms. Berger. I think we heard yours, but just in case.
Yes, good morning, Your Honor. Ariel Berger here on behalf of Father Donald Bundy.
Okay, Ms. Heiss.
Thank you, Your Honor. I was able to visit with this child in person and a lot of strengths happening. Really appreciate all the service workers' notes. We had psychological evaluations this time. These service providers are catching really intricate things at this point. You know, the bond has been, the foundation has been laid and they're finding, I think it was car insurance or something was due and the parents hadn't planned and the support person helped them plan ahead. And what's really cool is these parents are willing to rely on family to get back on their feet and to get a good understanding of their duty as parenting. So they live with paternal grandparents and paternal grandparents charge them rent, which is helpful to us so that they can understand what it takes, how much work it takes to support a household so they can be independent at some point, but there's no rush. The placement, paternal grandparents had saved some of the rent money back and had it ready when this extra bill came up. So it's just such an amazing team of people working together. I intend in the future to really encourage parents to seek out family members. They are very motivated to help their own. So this is a really great example. I look forward to closing this eventually, but just so many strengths. The child has all of his needs met. He's growing and meeting milestones. And this father had a case before. Mom has a case open and she's at a visit in Macomb County with those kids and she's almost doing well enough to maybe resurrect that case. I'm not sure, but she knows she's doing well. I know that she'll zoom in if she can, but in her absence, I just want to say that it's that relationship that she's built with those paternal grandparents. She respects, she knows her role, that it's just a really great environment. And I encourage the agency to continue to not emphasize independent housing, because this is a real multi-generational success, and the child is really benefiting. And that concludes my report. Thank you.
Witnesses today, Ms. Thomas.
Thank you, Your Honor. I would ask that Ms. Dillon be sworn in to provide her report. Ms. Dillon, you have been the foster care worker for this case, correct?
Yes,
And you provided a court report for today's hearing. Is that correct?
yes, it is.
In your report, there are several attachments, but I just want to make sure, are there any updates or modifications that you are aware of that need to be made to your report or any of the attached documents?
Just a couple little things. Mr. Bundy is no longer working at the Advanced Auto. He is now working for Bundy's Lawn Service. So he continues to have and maintain employment. I met with both parents yesterday, the placement and the child, and both parents recognize right now they have areas that they need to address. Mr. Bundy is willing to check into a medication assessment just to see if that would be helpful for him and to address his anxiety and his ADHD. And Ms. Gleason is recognizing that her depression's getting a little bit worse right now, so she's got a med review scheduled today so she can address having her medication increased if needed. So both parents are working on communicating, acknowledging things, and willing to address with their services and such. It is the hopes that the parent education program will be done by the end of the first week of November. And at that point, if a 90-day review is to occur after that, if the parents continue to progress as they are, then it's hopeful that we can ask for an FRP recommendation at that point. But today's hearing, I would like to ask for discretion to go to unsupervised visitation for Ms. Gleason immediately, and then Mr. Bundy when he's ready.
Thank you for that. And at this time, what is the substantial risk of harm if the child were to be in the parent's care and custody solely? I know that the family is living together, but if the family weren't living together, what would that risk of harm be?
At this point, we haven't had unsupervised parenting time. We haven't finished the parent education program. There's little things that the parents would like to address as far as their medication to address their mental health. I think in the near future, we will be looking at reunification, but at this point right now, I just don't think the parents are fully ready to parent full-time.
And overall, how would you describe each parent's their respective compliance with and benefit from their acute service plan?
Both parents are completely compliant. They're doing everything that's been asked. They go above and beyond and seek out additional services for themselves when they feel they need it. Mr. Bundy's going to work on his focus. He's doing a great job with parenting his son, but he needs to make sure he maintains that focus fully. And, you know, part of that can be caused by the anxiety and the ADHD. So they're both, in my opinion, completely compliant.
And just to confirm or clarify, any efforts or reasonable accommodations that are being made to ensure that both parents understand what is required of them, the reports that are written, they understand what is being written about them, anything that you are doing to ensure that?
Yes, I do review the reports with both clients. They also have the support of Linda Edwards to review any of the reports, and Ms. Edwards does periodically go through the case service plan with them just to make sure that they're on track and they know what's expected. But yes, they have service providers as well as the maternal great-grandparents of Remington that review paperwork and help them answer questions when they need it.
Wonderful. In some of the reports, there still seems to be a little bit of a concern about the focus as it relates to dad. And is that what you are also referring to during the time focus on the child when you're talking about maybe pediatric evaluation to determine whether medication is appropriate?
Yes.
Okay. Is the child getting any sibling visits?
Yes, he is attending this, the parenting time in Macomb County at least once a month. I think at this point it has been at least twice a month. And then, Mr. Bundy has children that are not under the jurisdiction of any court, and Remington is able to visit with them when dad sees them.
Okay, and thank you for clarifying that. I was a little confused from the report. I know that there's release or adoption and wasn't sure dad's parenting time with his children. So I appreciate that clarification. Are there any outstanding needs that this family has or the child has that are not being addressed quite yet?
Not at this time. They have all the services in place to address their needs. They're actively participating in those services. It is the hopes that if they continue with the progress they're making at this point, we can be asking for FRP at the 90-day review.
Okay, thank you. Is there anything else you would like to bring to the court's attention today?
No.
Thank you. With that, Your Honor, I will move to admit the court report and its attachments.
No objections.
No objection.
No objection.
Thank you. They are received. Questions, Ms. Berger?
None, Your Honor.
Mr. McCrum?
Do you agree with the guardian ad litem's assessment that the extended family situation is a good living environment?
Yes.
Okay. And there's no need for them to seek any independent living, that they have suitable housing. Would that be agreed?
Correct.
Okay. And when you mentioned the FRP program, that's a family reunification program, which is kind of a step before case closure. Am I correct?
Yes.
Nothing further.
I have no questions.
Any redirect?
No, Your Honor.
All right. Thank you for your testimony. You may return to your seat, please. Any other witnesses?
No, Your Honor.
Ms. Berger?
Mr. Bundy, do you have anything you want to testify to today?
No.
Okay. I have no witnesses in, Your Honor.
Mr. McCrum?
Unless my client has rejoined us, no, Your Honor.
She has, but I'm not sure what her kind of activity is. I know she's able to probably hear us, but I'm not sure she'd be able to participate.
If she can't participate, then no, so there's been a very positive report.
Yes,
No witnesses today. Thank you.
any comments?
None, Your Honor. Just asking for a standard 90-day review. Thank you.
Likewise, Your Honor. I would just ask that the department continue to work with my client. It looks like we are actually nearing a possibility of formal reunification in this case, so that's wonderful. And I would just encourage my client to continue doing what he's doing. Thank you.
I'm not sure when my client joined, so for her benefit, I appreciate that the agency reports she's in complete compliance, which means she's doing everything she's supposed to do. They're requesting unsupervised parenting time moving forward for her, which is also a very good positive. They also mirror the response of the guardian ad litem, and that the living situation with extended family is a good thing for everybody. And lastly, we agree with the expectation of the agency that after the next 90-day review, we'll move into a case closure by transitioning into a family reunification program, which is a step before closing the case. So complete compliance, I don't think you can get any better than that, Your Honor.
No comments. Thank you.
All right. For our next review, Ms. Berger, could you tell me, are you available Monday, October 23rd at 2:30 or 3:30?
I'm available anytime that afternoon, Your Honor.
Unavailable?
I am available.
I'm sorry, I couldn't understand you.
I am available that day.
Good, okay.
Because that's not the full 90 days, it's not anticipated that FRP would be done. I wonder if we could do the whole 90 days so that we can, have a promise, but either way is fine.
All right, that will take us out to November 14th, would be our full 90 days. But if anything happens, that doesn't leave us any room for adjournment, right? So that's why I usually build in a couple weeks at least to do that, but I'm happy to go to full 90 if everybody's available the 14th. I have all day, so if there's a time, Ms. Berger's usually our hardest one to work around. So if there's a time that day or on the 13th, at this point, I can accommodate that, Ms. Berger.
I'm available on the 14th, Your Honor.
All right, we can start at 9.
Yes, Your Honor, thank you.
So we'll set our next review for Tuesday, November 14th at 9 a.m. In the meantime, the court does find that all interested parties are given notice for purposes of today's review hearing, but hear that the family is doing well and functioning in a fashion that is meeting the child's needs. I will grant the request to expand parenting time to include unsupervised. I'm happy to do that. I would encourage Mr. Bundy to continue looking at what you need to do to continue to be successful. Congratulations on that.
Thank you, Your Honor.
You're welcome. Congratulations also to Ms. Gleason for her progress, and to both of you for acknowledging that using the help of your family is the wisest under the circumstances and is in the best interest of your child. The placement with relatives will continue pending further reviews with the expansion of parenting time and the understanding that those services continue to be needed. I'm familiar with the family and the parents, and I know that there's a long history here. So I will be looking for you and Ms. Gleason to continue to demonstrate that you can be successful in the long term so that we know that your son will be in good hands for the long run, not simply the short. So that being said, his placement will continue with relatives pending our next review hearing. We do find Ms. Heiss to be in compliance with her obligations. Thank you. Thank you. As well as Ms. Dillon, thank you for your efforts.
One question, Your Honor. Will you be requiring my client's presence as she seems to have connectivity issues next time?
Well, we'd love to have her available to us to participate. So if she'd like to participate, then that will be necessary.
I would just encourage her on the record if you could show up so we can discuss.
Yeah, if you're able to be here, I think that would be best.
That's her visit day with the other kids in the school.
Oh.
So the visitation will resume for the kids in Macomb County
Yeah,
after
they'll
school
be in
hours.
school, the kids will be home in
Okay.
school, so that's why we'll change the date for
Okay.
visitations.
So it will be clear for her at 9 a.m. We encourage her to come by in person.
Thank you, Your Honor.
Yes, very well. All right, unless there's any questions, I'm gonna go ahead and cut the order that reflects my findings today, and we'll see you all November 14th at 9.
You'll be in.